On May 15th, 2008, after we waged a 4-year-long legal battle, we finally won a landmark victory in the California Supreme Court for same-gender couples who wish to marry in California. Last night, opponents sought to reverse that decision with Proposition 8, in which they once again sought to restrict legal marriage to a man and to a woman. That proposition appears to have passed by a narrow margin. As a result, today, we will file a writ with the California Supreme Court on behalf of Robin Tyler and her spouse, Diane Olsen, challenging its constitutionality on several grounds. In our case in May, the California Supreme Court ruled that the Equal Protection Clause in our California Constitution protects the rights of lesbians and gays to marry the person of their choice. The court, and for the first time, recognized homosexuality as a, quote, suspect classification, end quote, under the Equal Protection Clause of our state constitution, thereby requiring a strict scrutiny test, which test was not and cannot be met, the court so held, in marriages limited to a man and a woman. Prop 8, if it passes, conflicts with the Equal Protection Clause. If marriage is now limited to straight couples and excludes gay couples, then it is inconsistent and in conflict with the Equal Protection Clause of our state constitution. We will argue to the court that Prop 8 is a disguised revision to the Constitution, which cannot be imposed by the ordinary amendment process, which only requires a simple majority. We believe that then the court must hold that California may not issue marriage licenses to non-gay couples, because if it does, it would be violating the Equal Protection Clause, as straight couples would have more rights by being allowed to marry than gay couples. If Prop 8 had said that the California Constitution was amended to limit marriage to people of the same race only, would that be constitutional under our state constitution? Of course not, as it would violate the Equal Protection Clause and the seminal case of Perez versus Sharp, which the Supreme Court decided 60 years ago. We will also argue that Prop 8 improperly revises a recent opinion, the Supreme Court's recent opinion defining the constitutional fundamental right of marriage. The state constitution provides that revisions to the Constitution require a 2/3 vote of the legislature or the convening of a state constitutional convention, and a proposition requiring only 50% is not available to the electorate to accomplish the revision to our Equal Protection Clause. Lastly, the constitutional requirement of separation of powers, we will argue, does not permit the use of the proposition format to remove and/or circumvent the judiciary in determining the interpretation of what is or is not a fundamental liberty right, and who is not protected by the Equal Protection Clause. The apparent passage of Prop 8 in California has been a heartbreaking experience for our clients, Robin Tyler and Diane Olsen, and millions of other same-gender couples who have married or wish to marry in California and throughout the nation. All they have asked for is equal rights under the law, and equal respect and dignity for their families and their committed relationships. Our law firm is honored to continue this great civil rights battle for them. We will never give in, and we will never give up. We will continue to be the change we wish to see in the world, and we will never have another season of silence until same-gender couples enjoy the same rights as non-gay couples on this green earth. And this is a copy of the lawsuit, which we have sent down for filing directly with the California Supreme Court. So it will be filed today. And now it's my pleasure to present Robin Tyler.
Hi.
Move over a little for you.
You didn't think we were going away, did you? You know, California, where chickens now have more rights than gay people. But we voted, by the way, for Prop 2, yes, and I'm glad it passed. All morning, I have been getting calls and emails from couples who have been crying, who either came to California to get married, or were coming to California to get married, or were in California and got married, and they could not believe that people would dare to vote our rights away. This has never happened before. And the anguish that our community feels nationally is overwhelming. And we are not going to take this lightly, and we are not going to go away. This is not culture war. A lot of times the press refers to this getting married as a culture war. This is a civil rights movement, and I'll give you the definition. Civil and political rights are a class of rights ensuring things such as the protection of people's physical integrity, procedural fairness in law, protection from discrimination based on gender, religion, sexual orientation, race, etc., individual freedom of belief, speech, association, the press, and political participation. This is a civil rights movement. It is not about our lifestyle. It is about our lives. And to be able to vote to take us out of the Constitution, for the first time in American history is frankly shocking, and at the same time brings to mind how much work this community needs to do nationally. We do not have one civil right on a federal level, not one. And we intend to fight this out. I am still married to Diane today. I do not want the word domestic partnership. We want the word marriage. We cried this morning and then we pulled ourselves together. We love each other. Our relationship is not worth less than heterosexual relationships, and this is not a religious issue. And so we will fight until the end, and in the end, we will win. We want to thank the law firm John West and Gloria Allred for taking this case again for us, and we want to assure our community all over the country that it is not over, that we will fight until our dying breath, until we have the right to marry and every other legal right in the United States. We're citizens, and we intend to be full citizens, and as the California Supreme Court says, we're not going to stop fighting until we're equal under the law. If we cannot get married, and the word marriage is not offered to us, then why is it being offered to straight people? So we really, really need to think about equality under the law and what equal rights means. Thank you.
The fact that some people would like to undo or I do makes me very sad. We're not going to stop. We're not going to stop. I love Robin. We just want our equal rights. And I am surprised at this day. I am surprised it rolled out this way. Thank you, Gloria and Mike. Here we go again. There are other things I would rather be doing, I assure you.
There was segregation, and African Americans had to drink from separate water fountains next to the white water fountain. They called that equality, separate but equal. And they could say, but after all, it's the same water. But it isn't the same water. What it meant was you are not good enough to drink out of our water fountain. Separate is never equal. The word marriage itself is very important to us because our relationships need to be, we don't believe in marriage segregation. And the minute you put another word to it, it means that our relationships aren't as valued or important as heterosexual relationships. And so we're not going to drink from the separate water fountain of marriage. We want equality, and equality means the word. It's not a religious institution. Marriage, there's no such thing as same-sex marriage. It's marriage equality. We want the equal.
And we shall overcome. The battle continues.